Ethics for Research Involving Human Subjects, Module 2, Privacy, Confidentiality, and Vulnerable Population. Adapted from learning materials in the CITI course in the Protection of Human Subjects, authored by Lorna Hicks. From an article by Susan L. Rose, Ph.D., and Charles E. Petrie, B.A., from Journal of Occupational Environmental Medicine, 2002, Volume 44, pages 801 to 805. The importance of protecting the privacy of research subjects and ensuring confidentiality of research data is widely acknowledged. The right to privacy is highly valued in the United States and secured by laws other than those for protecting research subjects. For example, the Family Educational Rights and Privacy Act, FERPA or FERPA, is designed to protect the privacy of students' educational records, and the privacy rule of the Health Insurance Portability and Accountability Act, HIPAA or HIPAA, describes conditions under which researchers can access and use private health information. Scientific societies have also adopted guidelines that stress the need to respect the privacy of subjects. The common rule states that in order to approve research, the IRB shall determine that, when appropriate, there are adequate provisions to protect the privacy of subjects and to maintain the confidentiality of data. According to the IRB Guidebook, published by the Office of Human Research Protections, privacy can be defined in terms of having control over the extent, timing, and circumstances of sharing oneself, physically, behaviorally, or intellectually, with others. Confidentiality pertains to the treatment of information that an individual has disclosed in a relationship of trust and with the expectation that it will not be divulged to others in ways that are inconsistent with the understanding of the original disclosure without permission. Thus it follows that privacy, a right, can be violated. Confidentiality, an agreement, can be breached. Confidentiality procedures, as described during the informed consent process, allow subjects to decide what measure of control over their personal information they are willing to relinquish to researchers. It is not always the case that information provided by research participants must be protected from unauthorized or inadvertent disclosure. Some participants want to be identified and quoted. Some agree to have their photographs or audio or videotapes archived in collections available to the general public. The federal regulations define private information to mean, quote, information about behavior that occurs in a context in which an individual can reasonably assume that no observation or recording is taking place, and information which has been provided for specific purposes by an individual and which he or she can reasonably expect will not be made public, for example, a school record, close quote. This definition offers a yardstick for differentiating between public and private behavior, and whether it is reasonable for subjects to expect privacy in a particular context. It would be unreasonable to expect that behavior on a street corner is not public, but reasonable to assume that behavior in our homes is private. However, individuals may identify private spaces in the midst of very public ones. For example, parents taking their children to a city park might consider it a violation of privacy if the interactions of their children were recorded using long-range recording devices. There is a conundrum here for investigators and IRBs. Subjects' expectations form the basis for making distinctions between public and private behavior. In other words, privacy is in the eye of the subjects. Yet the reasonableness of their expectations must be assessed in some way. Investigators and institutional review board members will have to make judgments about what is private information based upon their knowledge of the population and the context in which research will take place. Expectations about privacy will vary among cultures and among countries. Individuals' ability to control access to their persons and to their personal information is determined by a variety of factors, including socioeconomic status, age, and circumstance. For example, information about welfare rolls is public information. Information about personal stock portfolios is not. Minors have fewer rights to privacy than adults. Institutionalized persons may have significant limitations on their ability to control personal information. While not an exhaustive list, the following material highlights some concerns about privacy in the context of research. 1. Covert observation. 2. Privacy and study questions. 3. Communicating with subjects. Covert observation. Most research involves asking subjects to provide or release information voluntarily, following an informed consent process. Privacy issues arise in regard to information obtained for research purposes without the consent of subjects, such as through observational studies. Observational studies raise serious ethical concerns when they access information that individuals might choose not to reveal, or take away individuals' rights to control information about them, regardless of how innocuous it may be. The following questions might be used to assess the ethical soundness of observational research. 1. Is private identifiable information being collected about subjects without their knowledge? For example, covert observation recorded on videotape, in a situation in which individuals could reasonably expect privacy. If it is, then the following questions would also arise. Would reasonable people be offended by such an intrusion? Can the research be redesigned to avoid the intrusion? 2. Would information gathered through covert observation place the subject at risk if disclosed, for example, documenting illegal behavior? 3. Is the invasion of privacy justified by the benefits of the study? In other words, is the knowledge to be gained important enough to involve subjects without their consent? 4. What, if anything, will the subject be told later? Privacy and study questions. Invasions of privacy can occur if subjects are asked questions that they find intrusive. If a survey instrument contains questions that individuals might find to be intrusive, they must be informed. Studies about sexual behavior, childhood abuse, use of psychotropic medications, and other personal topics should include a disclosure in the consent form about the sensitive nature of the questions. The survey instrument or interview process must be designed so that a subject can choose not to answer any question that makes him or her uncomfortable. The subject should also be informed if the study materials include disturbing images, such as depictions of violence. Although there is considerable variation in how people define the right to privacy, there are nonetheless community and cultural standards that should be taken into account when designing research. Topics that are considered appropriate in one setting may be offensive and off-limits in another. Communicating with subjects. If a study is about stigmatizing conditions, illegal activities, or life experiences that subjects may not want others to know about, communications with the subjects should not reveal their participation to others. A method of communication that is of particular concern is email. Employee email is not secure, and some home accounts may be accessed by anyone in the family. Telephone calls to subjects at home may also be of concern. It may be appropriate to script calls so that no information is revealed about the caller or the subject to anyone other than the subject. In some cases, it may be appropriate to educate subjects about possible violations of their privacy. For example, researchers may counsel subjects to make sure their home computers are secure or to close their browsers after completing an online survey on a sensitive topic. Child abuse reporting. Most state laws identify individuals who must report suspected child abuse and neglect. This requirement should be described when child abuse and neglect might be revealed in a research study. Such studies could involve at-risk youth, school-based interventions, or parenting practices, among others. On the other hand, there are many studies in which it is extremely unlikely that the topic would arise or that the researcher would be in a position to observe neglect or abuse. For example, a study of decision-making strategies using computer-based activities would not generate information about child abuse, and there would be no need to discuss reporting requirements during the consent process. Other state reporting laws. State reporting laws may cover such matters as specific communicable diseases, the intent to harm oneself or others, and elder abuse. Investigators should check with their IRB about state laws. Certificates of confidentiality are issued by the National Institutes of Health, NIH, to protect identifiable research information from forced disclosure. Certificates of confidentiality may be granted for studies collecting information that, if disclosed, could have adverse consequences for subjects or damage their financial standing, employability, insurability, or reputation. A certificate of confidentiality will allow the investigator and others who have access to research records to refuse to disclose identifying information on individual research participants in civil, criminal, administrative, legislative, or other proceedings, whether at the federal, state, or local level. Information that can be protected includes, but is not limited to, substance abuse or other illegal behaviors, sexual attitudes, preferences, or practices, genetic information, psychological well-being. Certificates of confidentiality may be secured for any sensitive research, regardless of funding source. In fact, the research does not have to be funded. The protection of the rights and welfare of human research subjects is required whenever the United States government funds such research. The Code of Federal Regulations, Common Rule for the Protection of Human Subjects in Research, is a regulation that has been adopted by 17 federal departments and agencies. This regulation defines the standards and processes researchers and research institutions must follow to safeguard human subjects. There are several provisions in the Common Rule for the protection of vulnerable populations. Vulnerable persons are considered to be those who are less able to defend themselves than other persons in a given setting or situation. If the term vulnerability is limited to only those groups usually considered, children, prisoners, pregnant women, then workers will not receive appropriate additional protection from harm. Vulnerability of a worker as a research study subject can be referred to as paycheck vulnerability. This occurs when studies are conducted in the workplace, especially in those workplaces that pose real or perceived health and safety risks. Such workplace environments are as varied as educational institutions, chemical factories, hazardous waste cleanup sites, research laboratories, military settings, weapon production facilities, clinical and research laboratories in hospitals and academic medical centers, NASA spacecraft, power plants, and aircraft cabins. While each of these workplaces presents different scenarios for the employee and provide different study opportunities, vulnerability is related to the fact that the employer often promotes participation of workers. The coercion potential lies in enrollment or non-enrollment for the study as well as loss of job, career, or benefits due to study findings. This vulnerability issue is often a low-profile and subtle issue. Unions too often promote worker participation with the expectation or hope that entitlements may follow study entry or study findings. This is another type of coercion as well. Workers may experience pressure from supervisors to participate, not to participate, or to respond to a study in a way the employer or union may promote or perceive as advantageous to the organization. Additional vulnerability, for example job loss, job restriction, health impact, relates to individual or group study findings. The ability to give informed consent may be compromised, diminished, or negated. The results of the study can affect the livelihood or personal security of the worker or other workers. Risks from the impact of study findings may include the effects on individual entitlements, impairment of family relationships, possible threats to job retention, peer pressure, constraints to job advancement, and the ability to obtain and retain mortgage and health insurance. The findings from research studies also may present significant financial implications for individuals themselves, corporations, unions, or the government, for example, job loss, job restriction, health impact. These risks, if properly addressed, can be effectively managed to avoid harming workers' rights. Why do we need these studies? Health and safety of workers has been improved over the decades through workplace studies that broadened understanding of exposure pathways, control methodologies, and better detection techniques and devices. Why are these studies research and not operational improvements or observations? A study becomes research when the intent of the project is to gather data and contribute to generalizable knowledge, to improve health practice, and extend benefits of the project beyond the individual study participants. These studies also become research when data are collected that is not related to worker health care or when workers are tested with unapproved or not validated diagnostics. Worker studies require review by the Institutional Review Board, IRB. The common rule ideally requires the establishment of a formally and appropriately constituted Institutional Review Board, IRB, to oversee the protection of human subjects in research. Whenever possible or feasible, local IRBs overseeing workplace studies should have a worker member or worker consultant as needed. When the researcher is not employed by an organization at the study site, the local IRB review may be coordinated with an IRB at the researcher's home institution, or, if no other recourse, be the sole IRB of record. Once the question of research versus not research has been settled, a human subject's research plan should be given top priority. Such a plan is a review process that includes a scientifically meritorious protocol with a records management strategy, an objective, hypothesis, and an endpoint, a locale-sensitive method of communicating and interacting with the community and other stakeholders, review by an IRB of record. All stakeholders' roles should be considered in balancing the risks and benefits of the research. The IRB's role includes continued involvement in new issues as they arise during the study. Ideally, the research plan should recognize and involve all stakeholders from the outset. A complete research plan should assure accurate and full communication, appropriate scientific peer review, IRB review, and dedication of resources to ethical issues, as well as to the conduct of the study. IRBs may be concerned with risks posed by paycheck vulnerability. The paycheck vulnerability relationship between subjects and employers is complicated by the ambiguous definition of research, the employee relationship with the employer's occupational medicine physician, analogous perhaps to the clinician-researcher conflict, by unstated or organizational agendas promoting studies to determine or to suppress risk or to obtain entitlements, supervising personnel researchers asking for biospecimens from an employee, organizational ownership of personnel and occupational health records. Employer ownership of employee records and the absence of a human subjects protection system in settings remote in philosophy and mission from biomedical or traditional human subjects research increases the risks for participants and makes studies more difficult to identify and manage as human subjects research. Historically, ethical expectations often have not been implemented routinely in workplace research. However, enlightened employers in the private sector, especially where hazardous materials are used or liability issues prevail, have adopted excellent scientific and human subject review systems. Federal regulation adherence to these rules is required in public sector sites or federally funded studies, but is voluntary in private sector sites for non-federally funded studies. Research environments have many settings where workers or employees may be coerced into serving as study subjects. These differ from work sites like factories or weapons plants or industry because they have or should have a culture of compliance, an IRB, and policies. Non-traditional settings do not have these features and thus require education and culture change to protect subjects. This effort can follow the funding when federal money is involved. All stakeholders must be made aware of and participate in addressing the special needs and issues that apply to research using workers as study subjects. The number of worker-related studies has increased significantly in recent years due to employee health and safety fears and/or political concerns about exposures and risks to health. Hippocrates states that, quote, "Whenever in connection with my professional service, or not in connection with it, I see or hear in the life of men, which ought not to be spoken of abroad, I will not divulge, as reckoning that all such should be kept secret." Close quote. Researcher access to confidential records adds to the vulnerability of workers who participate in workplace studies. Inappropriate release of individually identifiable health or other personal data could adversely affect a worker's retention of a job, insurance, or other employment-related benefits. To avoid or minimize these risks, the study design must include adequate safeguards to protect the confidentiality of the information collected. A plan for the proper management of study data and records should clearly define the 1. Control of the collected data. 2. Who is authorized, approved to access, use, or disseminate study data or results. 3. Disclosure of that use to the subject. 4. Use of personal identifiers. 5. Use or inclusion of study results in employee personnel or medical records. Where several studies are in progress with the same worker population, the risks to privacy and confidentiality are likely to increase, requiring even more diligence in the management of confidential data by investigators and by those monitoring the studies. Contact and consent materials and research plans must detail the risks, the safeguards, as well as limits to confidentiality provided by law. The IRB, the researcher, and the subject must be informed of the limits and loopholes in the privacy laws governing workplace medical and research records, as well as ownership of data that may or may not be property of the employee, and applicable state-local laws. The privacy situation currently is clouded by federal laws, HIPAA, and by many state laws that address specific situations such as genetic testing and privacy. Newer technologies and electronic transmission of medical records exceed historic legal protections available for privacy. The Privacy Act of 1974 allows routine user access for researchers and others to obtain federally owned occupational medicine records. The collection of federal employee information was originally designed to provide information for government use and, secondarily, to offer records, including occupational, for health and safety research, hence the routine user clause. In practice, this has become a major loophole for giving personal, private, identified health and personnel information to a variety of routine users. It is problematic and is mentioned here to inform the reader, who may know HIPAA, the privacy rule, but may not be aware of the Privacy Act of 1974. The research use of genetic data and biological samples creates additional and complex ethical issues. Some ethicists and researchers have argued that genetic screening or testing should have no role in the workplace because of employment risk potentially associated with genetic screening or testing. At a minimum, when studies or medical monitoring include the collection of biological samples, all planned future uses of that samples, identifiers, and the data obtained from the samples must be fully explained and accepted by the participant before beginning the study. Federal or state guidance applying to use of biological materials in hospitals or biomedical studies also applies to the use of such materials in studies in the workplace.